The first thing that I'd like to talk about is just the Jehovah's Witnesses and the Supreme Court. Between 1938 and 1946, the Supreme Court handed down 23 opinions dealing with the Jehovah's Witnesses. It's an enormous number of cases for such a short period of time. During that same period, the witnesses were involved in hundreds of cases, not just 23, hundreds. And they involved some really profound issues: speech, religion, freedom of assembly, freedom of conscience in the context of military service. These were really important, not only for the witnesses themselves, but more broadly for all Americans. It's important to realize the court today we think of as being concerned with civil liberties and civil rights, and you can pick up the paper frequently and read about the court sort of rendering judgments in these matters. That was not always the case in the 19th century, and well into the 20th century, the court was concerned primarily with economic regulation and not civil rights and civil liberties. That's a phenomenon of this, or of the 20th century. The witness cases are important because they made the court think about those things for kind of the first time. In the 60s, there was something that has been referred to, that started in the 60s, the rights revolution. And one of the things I argued in my book, and I still believe very fundamentally, is that the witness cases sort of set the stage for that rights revolution in the 60s. By going to the Supreme Court over and over again, they made the justices sort of wake up to the Bill of Rights in a way that they hadn't previously done. And my favorite quote relating to this is from Justice Stone, and this is before he became Chief Justice. He wrote to a colleague, "I think that the Jehovah's Witnesses ought to have an endowment in light of the aid they give us in solving the legal problems of civil liberties." And they didn't get their endowment. I think that that was a sort of joking suggestion, but it highlights the fact that the members of the court themselves sort of realized this transformative process that they had experienced in the 30s and 40s because of the Jehovah's Witnesses. The first flag salute case, something of a different magnitude happened. There were actually violent attacks on Jehovah's Witnesses, mob attacks in places like Litchfield, Illinois, Rockville, Maryland, and Kennebunk, Maine. Witnesses are fired from their jobs. They're denied relief benefits. Children are expelled from schools. That is the one part that people sort of got right. The court had essentially given its approval to that kind of thing. It's an unprecedented reaction to a Supreme Court decision, and it's an unprecedented outbreak of religious persecution. Most people contemporaneously and subsequently have recognized it as the worst outbreak of religious persecution in the United States in the 20th century. And I'll read to you the attack in Kennebunk, Maine was a particularly grievous breach of civil liberties. A mob attacked a Kingdom Hall of the Jehovah's Witnesses and burned it more or less to the ground. And this is from the Boston Globe, its account of that persecution. "The mob made 2 visits and set 2 fires. The first burned out part of the building's interior but was extinguished quickly. The second completed the destruction. Before each of the fires, the mobs ransacked the building and removed tracts, furnishings, and members' personal belongings. These were burned in piles in a street of this ordinarily placid town." And at the time, people are sort of horrified that this is happening. John Haynes Holmes of the American Civil Liberties Union coincidentally owns a summer home near Kennebunk, Maine, and so he's attuned to what has happened, and he writes and sort of protests this persecution. And John Haynes Holmes said, quote, "This sounds like the Jews in Germany, but it happens to be the Jehovah's Witnesses in the United States." Others commented as well. Eleanor Roosevelt was writing a newspaper column at the time. She commented on it. And The members of the Supreme Court became aware of this. They often, I think, create the perception that they are these Olympian figures who are sort of above current events and shut out what is going on. And I think in general that is not true. And in the case of the flag salute and the Jehovah's Witnesses, it was definitely not true. Immediately, 3 members of the Supreme Court realized what had happened. Justice Douglas, Justice Murphy, and Justice Black, and very quickly realized that they had made a mistake. And they did something that's really extraordinary. They publicly admitted that they had messed up, which I know where I work. People don't do that frequently. I certainly don't. And members of the Supreme Court almost never do. And in a case that was decided between this Gabaitis case that I've been talking about and the Barnett case, those 3 justices wrote a little joint opinion in which they said that the first flag salute case had been wrongly decided. It's a really extraordinary public admission of their error. The mob attacks and the other forms of persecution sort of made them rethink Justice Frankfurter's opinion in that case. And they, to their credit, they fessed up rather quickly. And you can start doing the math in your head. The original decision in this first flag salute case had been 8-1. Justice Stone had been the one. Now Justice Stone has 3 more people on his side. It very quickly becomes in effect a 5-4 rather than an 8-1. Other things happen that sort of affect the dynamic of the court. In the Roosevelt era, I think that you needed a kind of baseball scorecard to see who was coming and who was going. Justice Burns served for 1 term, and Justice Jackson joins the court. And before he had been Justice Jackson, he was Attorney General Jackson. And in that role, in 1940, he was aware of these mob attacks as well. He's the country's chief law enforcement officer. And so reports of these mob attacks and firings and expulsions are crossing his desk. The Justice Department has an embryonic civil rights section. It's not the most effective thing at that point. It's sort of brand new. But they're funneling information to Justice Jackson, so he knows what's going on. He publishes a book shortly before he joined the court in which he hinted at his disapproval for that first flag salute decision, in which the book was The Struggle for Judicial Supremacy, and he singled it out as an exception to the court's usual vigilance, quote, in stamping out attempts by local authorities to suppress the free dissemination of ideas upon which the system of responsible government rests. So the Gabaitis decision as an exception to that vigilance. He also later wrote in some other correspondence, quote, when I came on the court, I agreed with Stone that I didn't think the flag salute was constitutional. So he comes on the court. Now, Justice Stone has himself, those 3 other justices who had admitted their mistake, and Justice Jackson. That's 5, and that's all you need. They get a 6th, a justice named Wiley Rutledge had served on a lower federal court, and those many hundreds of lower court cases involving the Jehovah's Witnesses. He had also written unfavorably about the first flag salute case. So that turns the tables. It's now a 6-3 majority against the flag salute. Unlike the first flag salute decision, the second flag salute decision meets with sort of widespread approval. My favorite account is from Time magazine, which in classic Time magazine fashion had a brief, concise article. And the headline of that story was "Blot Removed." And the remainder of our program, you'll hear from people explaining how and why that stain was expunged. Thanks.